Hi, everyone. My name is Kaitlyn. I am an associate in the IP Litigation Life Sciences Division at Venable, based out of New York. Today, we're going to be discussing hot topics in patent litigation. We're going to try and touch on as many as possible, cover updates in the various arenas where patent activity happens, the District Court, the Patent Trial and Appeal Board, the Federal Circuit, and the Supreme Court. I'm joined by three great panelists today, Megan, Sarah, and Amanda. If you each want to introduce yourselves, we'll start with Megan.
Thanks, Kaitlyn, and good morning or good afternoon, depending on where you are listening. My name is Megan Woodworth. I'm a partner and one of the co-chairs of Venable's IP Litigation Technology Practice Group. I began my own career doing a mix of patent prosecution and litigation. I then did a clerkship with now Chief Judge Moore, at the Federal Circuit. It was Chief Judge Michelle at the time that I was there. And did that for a year before returning to private practice, where I have since focused exclusively on patent and IP litigation and appellate work, representing a variety of clients in various industries, including medical devices, software, telecommunications, and automotive technologies. I've practiced before numerous district courts, as well as the United States Patent Trial and Appeal Board, the International Trade Commission, and of course, the Federal Circuit. So very happy to be here and presenting with this group. So thank you to ChIPs for having us.
Good morning. Thanks for ChIPs for having us. My name is Sarah Brooks. I'm an IP litigation partner in our Los Angeles office. I started my practice in New York, working in IP boutique Fitzpatrick Chella, doing exclusively patent litigation. Like Megan, I practice in U.S. District Court and before the PTAB. I'm barred in New York, California, and before the Patent Bar. And I serve as the Los Angeles office hiring partner for Venable's LA office.
Great. Thank you, everyone, for having me. I'm Amanda Dittmar. I am in-house counsel at Viavi Solutions. I've been there for the last 7 years, started out doing patent prosecution and litigation. I've actually, for my litigation, I've been lucky enough to work with Venable for many of them and Megan. They've been giving me a pretty good track record and making me look great in front of my business associates. It's so great. In fact, I've recently added on to my role. I now am doing a legal lead, or what I like to call mini GC, for our optical security and performance products business unit. They do some pretty fascinating technology over there. It's fun to be a part of. It includes things like optics that enable 3D sensing, special effects for anti-counterfeiting on currency, as well as we get to work with NASA on space exploration and satellites. So we're really having a fun time at our job and with the things we get to work with. Before we move on, I did want to say that just a disclaimer that my opinions today are my own and not Viavi's. And I also really wanted to thank Venable for having me and ChIPs for having me as well today. Thank you.
Thanks, Amanda. And just for those of us watching on a later recording, welcome. Thank you again to ChIPs. And we will be discussing hot topics in patent litigation. I think we're going to go ahead and start with what's happening at the district courts, because it's where most people think of where patent litigation occurs. And Megan, I think we'll start with you. Since the Supreme Court's TC Heartland decision, venue selection continues to be an extremely hot topic. What were we seeing, the trends that we saw after that decision?
Thanks, Kaitlyn. Yeah, I mean, most of what we saw was somewhat expected in that, at the time TC Heartland came down, the Eastern District of Texas, Marshall in particular was the tiny town that really put patent litigation kind of on the map and had, up to, I think at one point, 80% of the patent cases were filed there in different points in time. So just a really tremendous overbalance or overabundance of cases that were filed there. We have seen a downtick, which is what most people were expecting, but it probably hasn't been quite as significant as what people thought. We have seen on the other side, Delaware has obviously continued to get larger and larger in terms of where plaintiffs are filing. So many different companies are incorporated there that it's easy to make venue stick. We've also seen California become more popular because so many companies are based there and have a principal place of business. And then the newer districts that have popped up obviously include the Western District of Texas. In fact, and I've got just a few statistics here from Lex Machina, that in the 2020, so basically since the pandemic, the 2020 to 22 time period, the Western District of Texas was, during that 3-year stretch, the busiest of any. So it overtook Delaware, it overtook the Eastern District of Texas. 2,700 cases were filed there in that period, which accounted for 23% of all patent litigations. District of Delaware still definitely got its fair share, just under 2,300, which was, 19%. And then East Texas was now down to about 11%. So we still see a lot of favoritism in very particular districts, but what we've seen is that it's really shifted from East Texas now to really Delaware and West Texas. The big draw that people report is Judge Albright himself, as most of us know. He's the only judge in the Waco division of the Western District of Texas. So if a plaintiff wanted to get before Judge Albright, they would just have to file in that division. And he was doing things that a lot of plaintiffs saw as patent friendly. He was setting relatively fast track schedules. He was denying most, I would say, of the motions to dismiss or early motions to limit the case, at least until after claim construction. So plaintiffs really saw that as becoming a favorable district. He has continued throughout the pandemic to get a number of cases to trial. And so that really has been, I would say, the biggest trend that we've seen since the Heartland decision.
And in keeping with West Texas, I know the IP community thought that would change towards the end of 2021. Can you explain a little bit what happened there?
Sure. So what happened was, first we saw some rumblings, I guess I would say, from actually the chief judge. It went all the way up to the Chief Judge of the United States, who remarked in some of his annual comments about the disparities in some of the venue selection that he saw in patent litigation. And then we also saw concerns that were expressed directly in Congress, thinking that TC Heartland would have changed this, the inequities or the misbalance between patent cases and the districts in which they were filed. So it looked like at some time Congress might actually try to solve the problem itself. Ultimately, what we saw is the Chief Judge of the Western District of Texas issued a standing order that was supposed to have cases in West Texas distributed more equally. So the standing order basically said that in an effort to equitably distribute the cases that were filed in the Waco division in particular, that all civil cases involving patents shall be randomly assigned to a series of district court judges throughout the Western District of Texas. So that was really what I think you were referring to, that practitioners thought that there was going to be a big sea change. We had this bubble post Heartland of cases in the Western District. And then with the standing order, there was expectation that that would really change.
Great, thank you. And Sarah, turning to you now, what have we seen since that standing order came down? Has the randomization that it pointed to been affected? And specifically, are the patent infringement cases being filed in the Western District of Texas being equally distributed now?
Yeah, so the standing order Megan mentioned was, it came down in July of 2022. And so what we've seen since then is there's some shift, but probably not as significant as many patent practitioners expected. It doesn't actually appear that the patent cases are being doled out in a true randomized way. So I'll give you some examples. In 2021, there were 981 patent cases filed in Western District of Texas. And then 2022, there was 867. So a little bit less, right, between 981 and 867, but whether or not that's significant, I don't know. It's still the most patent cases in the entire nation. So, there may have been some discouragement from filing, but it's certainly not as significant. And then as to the randomization, Judge Albright is just still getting most of the patent cases. In 2022, for example, there were 470 patent cases filed since the July 2022 standing order. So between July 1 and December 31st, 2022, there were 470 patent cases, and Judge Albright got 53% of those filed cases. And then since January 1 of 2023 through, I think somewhat present, we looked up the statistics recently, there were 90 patent cases filed. He was still getting 41% of those. So a lot of, there's two thoughts. Either the standing order isn't truly random, and that maybe there's some ramp up period sort of behind the scenes where, they're going to gradually hope to achieve like true randomization, or, other commentators have said that, likely at least some of those patent cases going to Judge Albright could be related cases and they're being assigned to the lower numbered case. I personally don't think that would account for, the 53% or 43% that he's getting as compared to other judges in his district. So we're not seeing it be truly random, and we're not seeing like such a significant decrease as I think we would have expected from the standing order.
Great, thank you. And Amanda, I'd love to turn to you now. As in-house counsel at Viavi, which has a very significant patent portfolio of its own, you have been on both sides of the proverbial V. What is your perspective on venue preferences from the in-house point of view here?
Yeah, that's a really good question. And I do think that being on both sides is eye-opening to some of the competing interests that I'm seeing when it comes to venue preferences, especially often when we're a defendant, it seems that it's a non-practicing entity on the other side. So when it comes down to speed and likelihood of stay proceedings, we can win that, and we can sometimes lose that. So as defendant, our concerns are kind of wanting to be in a place where we feel like our arguments are getting a fair shake from juries. And then another big concern with we don't have most of our employees are not in Texas, so that location is a big concern for us. And wanting to be in a place where it's convenient for our employees. Especially when we're in defense, we're inevitably going to have the employees come to the court and help in the defense of the case. So, I mean, it's hard to drag employees away from the day-to-day of trying to make money in order to help with litigations. And it just complicates things even more when we have a longer commute to the courtroom. That compounds the issue. But then, of course, the other side of that coin, as a plaintiff, I've definitely seen the benefits that are often associated with the Texas courts. I'm a little biased here, but I like to tell people that I feel that Viavi is the type of company that the patent system was made for. We have some great inventors who end up putting products out, I think, years before the competition, based off of just time invested and also money invested in new inventions. So caring about the company, it's frustrating to me to watch, but it's also really hard for me to explain to the business shareholders why we have to wait so long for what we feel like is justice, especially while they're watching competitors maybe win sales, or we have to lower prices in order to compete with companies. So we just feel like they didn't have to put the investment into because they weren't developing. Maybe they were just reverse engineering. So the key for me advantages in the Texas courts, I think, are what they are for every plaintiff or most plaintiffs, is that it's the swift justice. We're less likely to get stayed for proceedings, and we're also more likely to get a trial date. And as a plaintiff, those can just be invaluable.
Thank you. And I'm going to move us along to our next topic, which a big area of interest for everyone has been litigation funding trends, and notably what certain courts and particular judges are now requiring plaintiffs to disclose, in particular information regarding to their business relationships and litigation funding trends. We saw Judge Connolly in Delaware come out with a standing order that got a lot of pushback on the plaintiff's bar, including mandamus petitions. Sarah, do you want to start us off there about what's going on?
Yeah, so Judge Connolly, sorry, as you mentioned, in Delaware, has a standing order regarding litigation funding disclosures. And so what he requires are for parties to disclose the identity and the address and other sort of identifying information about the litigation funders, and then whether the funders' approval is necessary for any aspect of the litigation, but including settlement. And then a brief description of the nature of the financial interest. The other interesting thing about his order is he says that parties can seek additional discovery. So he doesn't limit it to those three things that I just mentioned, sort of the identity, whether or not they have control over the litigation, and a financial and settlement, and what their financial interest is. The standing order also says that parties could seek the actual funding agreement, other discovery. And then the third aspect of his standing order, and this is what got some press, was that it says nothing herein precludes the court from ordering such other relief as may be appropriate. And so it's this last point that he used, I guess, his discretion and that point in his standing order to further inquire and obtain discovery from a particular plaintiff called Nimitz Technologies. And that was a bit of an unusual case. And what Judge Connolly believed were there were various shell companies behind Nimitz Technologies, and that they were approaching really just totally unrelated individuals, assigning patents to them to hide the true nature of who was controlling the patent litigation. In some instances, there was like a food truck owner who was approached by this company called IP Edge. They assigned the patent to this food truck owner who really had no idea, what was going on. And so Judge Connolly used his standing order to obtain discovery about who was really behind some of these patent litigations. So Nimitz Technologies filed mandamus with the Federal Circuit, and this gained a lot of interest. There were a lot of amici briefs were filed from Electronic Frontier Foundation, U.S. Chamber of Commerce, Intel, other trade groups, all advocating to uphold Judge Connolly's standing order. And Nimitz Technologies was arguing for relief, saying that the standing order was contrary to patent law. Ultimately, the Federal Circuit actually denied the mandamus petition. But interestingly, Judge Connolly issued, I think it was almost an 80-page opinion justifying his patent or his litigation funding standing order, and again describing some of the kind of unique aspects of this case and the fraud that he believed was being perpetuated on the court, and justifying his that he really needed the ability to get behind who was behind these patent litigations. For me, I think it's a really interesting issue, and we'll talk more about some of the other districts that may or may not require or find acceptable to get into litigation funding arrangements. We all know about the initial disclosures, how, in initial disclosures, you have to disclose whether or not you have insurance, and if so, disclose that insurance agreements. And so, this isn't too far, in my view, not too far off of that. It's not codified yet in Rule 26, but it's interesting to compare the different districts and their approaches.
And going off of that, Megan, do you have any insights into how Judge Connolly's practice differs from other districts and or other judges?
Yeah, I was actually surprised. And I think some of this is in the long order that Judge Connolly himself wrote, because he was obviously getting all of the publicity, both positive and negative, for kind of the practice and the standing order that he created there. But he cited to a large number of other districts that have local rules that are very, very similar to what he did, including popular districts like the Northern District of California, District of New Jersey, Northern District of Georgia. Most of these districts have the rule, and it stems from the desire for the judges to need to know who the parties are or who the real parties and interest are, so that they can assess their own personal conflicts in the case. And that's obviously a potential subject for another webinar, seminar in and of itself. But all three of those are pretty similar. They're all worded differently, but they would require the disclosure of any person or entity that has a financial interest in any manner in the outcome of the litigation. On the other side, and those are just a few of the districts, but on the other side, again, we see Texas, East and West Texas, that have no such disclosure requirement. Again, those are not the only two. We just had talked about them earlier in terms of plaintiff kind of friendly venues. So again, we see a relatively plaintiff friendly approach in not requiring the disclosure of litigation funders. I read a recent article where Judge Albright was asked about discovery into litigation funding, and I'm paraphrasing, but he basically said, absolutely not. I have no interest in getting into that in the case. So we see that, at least some districts are still not requiring disclosure. They're actually prohibiting any or most discovery into litigation funding or who other interested parties might be in the litigation, in contrast to what we've seen from District Judge Connolly and some of the other districts.
I'll just add that probably another reason why West Texas and Judge Albright will continue to be a popular venue is just what you just said, Megan, which is he's said, no, we're not going to allow discovery into litigation funding agreements. And so, of course, NPEs or other plaintiffs that are funded are going to be motivated to file there or continue filing there, even with the standing order, for at least that reason.
Exactly. And I have one case in West Texas that involved a discovery dispute where we were trying to get information on that. He did hear it out, and it does seem that if you can somehow tie it specifically to interests or issues in the case, there's a possibility that they might get into it, but it certainly is their preference and their desire not to.
Great, thank you. I think now we'll go ahead and turn towards what's happening at the Supreme Court, which continues to show an interest in IP cases, notably Jack Daniels and VIP products. The oral arguments were heard yesterday. But let's start with a case upcoming where they have granted cert, Amgen v. Sanofi. What's the issue there, Megan, if you want to start us off?
Great, sure. This case, like so many that go before the Supreme Court, has a long and windy history. And I apologize if anybody on this call is involved and I get any of the facts wrong. But from my review and study of the case, it began back in 2014. Amgen had filed suit against Sanofi and others. The technology involves a cholesterol reducing drug. So obviously something that's really important to a lot of people. The defendants stipulated to infringement at some point in the case. So all that ended up going to trial, and it's actually had two different trials now, were Sanofi's invalidity defenses. It went up to the Federal Circuit a first time. The decision was vacated and went back a second time. There, the jury actually found in Amgen's favor. They found that Sanofi had failed to prove that the asserted claims were invalid for either a lack of written description or enablement, which were the primary challenges. But the district court overturned that decision, found that the claims did not meet the enablement standard in particular. And in 2021, the Federal Circuit affirmed that ruling. The standard that they applied, which has probably been the standard for the time period that most of us have been practicing, is whether the patent specification provides sufficient disclosure to allow a person of ordinary skill in the art to practice the full scope of the claimed invention without undue experimentation. So Sanofi had argued this was a genus claim in the life sciences context, and Sanofi had argued that there were millions of antibody candidates that would fall within the scope of those claims, and that the disclosures did not provide sufficient guidance, particularly given that antibody generation is an unpredictable art, to practice the full scope of those claims. So that was basically that is basically the issue. Amgen filed a petition for cert and basically said that that should not be the proper standard, that the Federal Circuit has taken the language of the Patent Act and gone too far, created too high of a hurdle. The argument is that the test is not consistent with the statutory language of the Patent Act, and that it actually chills innovation and invention and investment in invention by requiring so much, particularly as you think about it for foundational or really truly novel life sciences materials. The argument is that the claim should actually be entitled to a broader scope potentially, as opposed to being invalidated for having a lack of disclosure due to the foundational nature of the invention. So Amgen's brief begins very forcefully. I enjoyed reading it. It started and said, the Federal Circuit has once again imposed limitations on the Patent Act that are inconsistent with the text. So Amgen is framing the question as, should the Supreme Court go back and limit the enablement standard to just make and use the claimed invention as it's recited in Section 112, or is the Federal Circuit's test, which is that you've got to enable those skilled in the art to reach the full scope of the claimed invention or claimed embodiments without undue experimentation, is that proper? And they've described that as being able to identify and make all or nearly all of the embodiments of the invention without substantial time and effort. So based on past history, we've got to assume that if the Federal Circuit if the Supreme Court is taking a case from the Federal Circuit, they are probably going to change something that's happened. This case is a little unusual because the Solicitor General was asked for its views and actually said that they did not think that the Supreme Court should take the case. They noted that the test seemed to be working well, that Amgen did not articulate an alternative standard beyond the language of the statute. And neither side in this case was disputing that this really was an unpredictable art. I think what stands out about this case, though, is another point in Amgen's brief, which is that this is a case in which Amgen argues that it's a case in which the patents roadmap is sufficient, that every time one practices what's in the patent, you will end up with claimed an antibody that falls within the claims, and that no one, including Sanofi, had identified any actual antibodies that could not be produced using the patent's disclosures. So that's in contrast to other cases, including a much older Supreme Court cases that both of the parties have briefed, where there was proof that embodiments that would fall within the scope of the claims could not be derived from the teachings of the patent. So it'll be interesting to see. I expect that we will see some change. Whether the Supreme Court provides any more guidance, though, than directing courts to go back to the language of the Patent Act remains to be seen. I think what we will see, though, is probably a shift of the burden So it will really be up to defendants to make yourselves more in line with that older Supreme Court case where you are finding and going forward with embodiments that would fall within the scope of the claims that can't be determined based on the teachings of the patent. So that would be my expectation for what we'll see.
Great, thank you, Megan. Amanda, I'd also like to get your perspective from an in-house point of view. I know your portfolio is not in the pharmaceutical space, but it does involve unique materials and various technical applications. How do you think this will impact a company like yours?
Yeah, and actually that is one thing that we are looking at as to how the decision will be worded, if it will stick to kind of just the life sciences or pharmaceutical industry, or if it's going to apply across industries, and we're going to have to worry about how claims are interpreted going forward and how we have to draft specifications. So I can say that big cases like this can affect the strength of the portfolio of especially already issued patents. We ran into that recently where the highest court in another country kind of changed the way the requirements of claims. And it has had a big project to kind of reevaluate what we think our coverage is and what our competitors' coverage is now. Now that the way the law we thought it was coming down changed a little bit after the highest court came down. So I think that our ability to enforce patents is going to come into question, and how we drafted them depending on the decision here. And that's from my litigation role. On the other side, the prosecution role, big shakeups in how law is interpreted also kind of highlights to me the importance of keeping families alive, especially important families. It allows us to adjust claims later when new cases come out or maybe new interpretations come out. The downside of that in-house is cost, of course, and I also imagine a increased load on the patent office, but it definitely heightens my instinct to keep things alive until we see the results of this case. And again, depending on the results, I think we could see longer specifications, which again is going to count more cost to us, where we're kind of having to put in every single example instead of putting in large groups. The example I used or I was thinking of is materials. We often just list a few metals, and then in the claims we might say kind of a metal or metal oxide. So we might need to be listing every metal that could conceivably be part of this invention, which would increase the time and energy in the specifications. And then I think finally, if genus or very broad claims end up being shot down, I'm wondering if there's going to be an increased focus on Marcouche groups and claims where you have a choice that involves a selection from individual examples or species that are disclosed in the specifications. There's lots to think about with how it'll affect our already issued patents, as well as what we're going to do going forward for prosecution and drafting.
Great, thank you, Amanda. Very interesting case. I scheduled for arguments right now, March 27th, if anyone wants to tune in. The other big question that remains at SCOTUS is whether or not they're going to take on another 101 case and provide additional guidance on patent eligibility outside of the Alice framework. Sarah, do you have any thoughts there?
Yeah, so there's certainly a lot of, I would say, displeasure from district court judges and practitioners alike that they would like some clarity on the Alice decision and 101 analysis. I think the problem is that, last year, everyone was expecting the Supreme Court to take up the American Axle case, and they didn't. And that case there were a lot of amici brief filed in support of the Supreme Court taking that on. And it was a bit of an unusual one because it wasn't a software case. It involved a mechanical device, and that was invalidated under 101. And it was directed to a prop shaft for a vehicle that used a vibration reducing liner. So not the kind of invention you would ordinarily think would be patent ineligible. And so one of the criticisms with that case that the Supreme Court didn't take up was that there was no consideration for the level of the person of ordinary skill in the art, and that ought to be part of the 101 analysis and wasn't under Alice. And so I don't have the expectation that the Supreme Court will take on 101 this term. And in part that's because last year they didn't, and you would think that if they would have taken up that American Axle case. But what is interesting is that others have pushed for Congress to make a change. And so there was a proposed bill, I think it was from August of 2022, proposed by Senator Tillis, who's a Republican out of North Carolina. And it's called the Patent Subject Matter Eligibility Bill. And so one interesting thing about this bill, which is still pending, is that it proposes that the definition of useful include the level of ordinary skill in the art to a person of ordinary skill in the art. And it also provides specific examples of what is patent eligible and what is not. So for example, it says a mathematical form, you cannot obtain a patent on a mathematical formula apart from a useful invention or discovery. You can't obtain a patent on a non-technological, economic, financial, business, social, cultural, or artistic process. You can't obtain a patent on a mental process performed solely in the human mind. You can't obtain a patent on something that occurs in nature, wholly independent of and prior to any human activity. And you can't obtain a patent on an unmodified human gene, as that gene exists in a human body. And there's a couple of other examples, but it has received some support from the AIPLA, at least that it's a step in the right direction. Basically, it might not be 100% of the way there, but the fact that it's incorporating the level of ordinary skill in the art and giving specific examples as to, ideas that would not be patent eligible, like the ones I just mentioned, is a step in the right direction. And then I would say finally, USPTO Director Vidal has indicated, I think in July of 2022, so I'm not sure when it may come out, but she has indicated that she wants to issue better guidance for 101. So we may not get the Supreme Court to take this on, but we may get guidance from Congress and or the USPTO in the near future.
Great, thanks, Sarah. Amanda, interested to hear your perspective as well.
Yeah, I think I have a lot of the same thoughts when we were just talking about 112, but I will say kind of my gut reaction when we started talking to 101 were some flashbacks to after Alice and the big shakeup I felt like at the PTO. I remember, and I'm sure a lot of you will remember too, just in prosecuting applications, almost a standstill where examiners were really hesitant to allow anything until the guidance went through. So we saw a lot of extensions of time. We took a lot of rejections, and now of course we have the guidance. Good idea as to now how to draft new specs, and also how to get claims through the patent office, whereas a lot of things written before Alice it could have been a good invention, but just wasn't written correctly, or the way it was written was outdated, and you just weren't getting patents out of it. And now we're in a better place, definitely. And my gut again is almost the devil, and it sounds nice to have these new guidances and maybe smaller changes to the guidance than a big shakeup would allow the process to continue in a little better way. But obviously, I think that guidance either from the court or Congress or even the patent office could help in litigation and enforcing, because I know that's a different story than how things are going through the patent office. But definitely have an eye on any potential 101 decisions, as well as how they're going to affect prosecution and kind of the expansion of our portfolio, as well as how we can enforce already issued patents, like I touched on with the 112 issue before.
Thank you, Amanda. Another hot topic is what changes are currently happening at the Patent Trial and Appeal Board under Director Vidal, as Sarah touched on. Megan, what are your thoughts there?
So I'll actually go back to after Director Vidal was named to the patent office. The first chance that I saw her thereafter was actually at the Federal Circuit Bench and Bar Conference. And we had a small group that got her attention for a few minutes. And the hot topic that I'm going to discuss today was exactly what we wanted to talk about then, which is the FinTIV denials, which are the discretionary denials that the PTAB had really started to use with some frequency before she came to the office. It was a 6-factor test that was supposed to be used to balance, but to determine whether or not the PTAB should discretionally deny institution of an IPR based on parallel district court litigation. Obviously, the defense bar had trouble understanding that because, the entire basis or most of the basis for having IPRs was to be a parallel proceeding that would be less costly. And if either of those was supposed to give away, at least as the defense bar saw it under the enactment, it was supposed to be that the PTAB would take precedence over district court, whereas these FinTIV denials were really seen as it going the other way. So after Director Vidal took office, the guidance that she issued under her leadership did have a major impact on the FinTIV denials. The guidance said first that that the PTAB would not deny under FinTIV discretionarily where the review presented compelling evidence of unpatentability. They also said that the PTAB would not deny if the parallel proceeding was for an ITC proceeding as opposed to district court. And third, they enacted guidance saying that if the petitioner presented what was known as cetera stipulations based on a particular case at the time, but if you as a petitioner provided a statement that you would, or stipulation that you would not pursue in the district court litigation, the same grounds that were in your petition or any grounds that could have reasonably been raised, then they again would not discretionarily deny, because that was seen to have removed the possibility that there would be actual parallel proceedings taking place and the possibility of conflicting decisions. So that was the guidance that went out under her leadership. In February of this year, we saw that that Director Vidal actually issued sua sponte, did a director review of a case and vacated and remanded back to the board in a ComScope IPR proceeding, where the board had issued an institution decision that was based on this guidance. And what she confirmed, or what she clarified in that director review, was that it was the intent of the guidance to only allow for that compelling evidence merits determination if the first few FinTIV factors had suggested that denial was appropriate. So in that case, the board had looked first to see, okay, just in part of the regular balancing test, is there compelling evidence? And so her reissued opinion said, no, what I'd prefer, or what should take place, is you should look at the first few fintive factors, and only if they are leaning towards denial will we then look to, well, will a compelling case save you? So that was the state of play until earlier this month. Another case came out of the federal circuit, and this was based on a challenge to the PTAB's fintive practice that was led by Apple as well as a number of other companies, including Cisco, Google, I think Edwards Life Sciences, Intel were all part of the challenge, to whether or not the USPTO had the discretion to do these discretionary denials under 314 based on parallel proceedings. The Federal Circuit affirmed most of the rejection by the district court of those arguments, but actually did reverse one of the challenges, which is whether the PTAB's practice itself was improper under the APA, because it had not been promulgated through formal notice and rulemaking procedure, but was done through, a institution decision that then became precedential, in which there was then guidance issued, in which there was then a director review. And so the argument was, no, in order to affect such precedent, you actually have to go through the APA and make a formal rulemaking. The Federal Circuit said that that was something that these private parties could challenge. So the Federal Circuit reversed that aspect of the case, and it's going to go back down to the district court to then look at whether or not it actually is an APA violation. So the district court will be deciding that. And unclear exactly how long the merits challenge of that will take. I understand, though, that there is formal rulemaking underway by the PTAB for the fintive practice. So it'll be an interesting kind of race to see what happens first, if they get that through and completed, or whether or not we get additional guidance from the district court as to whether or not that was actually required. And obviously, it's one thing, the Apple case is one thing just as it's specific to the fintive decisions, but it obviously could have much broader implications to the PTAB practice as a whole. If the district court were to rule that the PTAB is not permitted to present guidance or make decisions precedential in a way that's going to impact other PTAB rulings, or whether that all is going to have to be done through the traditional notice and comment rulemaking process, which, as we all know, takes a tremendous amount of time. So that case, even if that case, I think, is one that we should all kind of keep an eye on, has a lot of broad potential.
Great, thanks, Megan. Sarah, also interested to hear from you about any other cases that Director Vidal has taken up and or issued other guidance in accordance with.
Yeah, there's a really interesting one that is unusual and new, and it's almost like a reverse troll situation. So it's this Open Sky IPR proceeding, which you all may have heard about. And so in this situation, Intel and another entity, VLSI, they were in a litigation. And what Open Sky did was they formed a shell entity. They filed an IPR against VLSI's patents. And then once the IPR was instituted, they contacted both sides. They contacted Intel and they contacted VLSI, and they offered, advocacy for either side, depending on who was going to pay them. And so for VLSI, whose patents it was, they basically offered to sort of throw the proceedings if they were compensated. And so it was that offer to both sides that came out in the litigation, and Director Vidal particularly found egregious conduct. And so she said she was very concerned about Open Sky's proposal to intentionally undermine the proceedings, that violated the duty of good faith and candor to the board. and that behavior alone was sanctionable. So what she did was she sanctioned them. She also dismissed Open Sky from the proceedings as it being an abuse of the system. And I think she left it up to Intel as to whether they would continue the IPR proceedings or not. But it was really nothing like that had ever happened before, as far as I'm aware. There had never been that sort of abuse of the system that had been uncovered, where there was a IPR filed and then an offer to both sides. So it was pretty unusual situation, and Judge I keep calling her Judge Vidal, Director Vidal stepped in, rightly so, and so that has made a lot of news recently.
Yeah, another part of that, Sarah, that I thought was really interesting, and again, kind of shows the precedent-setting nature of what happened, was before issuing sanctions, Director Vidal issued discovery to the parties. And I think part of then her frustration and part of the eventual sanctions was based on Open Sky not participating and not providing fulsome discovery responses. So again, kind of a new thing that we don't see, certainly haven't seen in the past. I don't know how much, that case is obviously an outlier, so I don't know how much we'll see it in the future, but just the possibility that the director can itself issue discovery to the parties is really unique.
Great, thanks, Megan and Sarah. Director intervention is definitely a very hot topic. At this time, we'll take some questions from the Zoom audience here. I did receive one in the chat relating to mandamus petitions at the Federal Circuit and just generally trends that we're seeing there. Megan, do you have any insight?
Sure. Mandamus petitions at the Federal Circuit continue to be used, certainly much more routinely than they were early in my practice. I think a lot of them that we're seeing, particularly in the last few years since TC Heartland, remain on that topic. Or even before TC Heartland, we saw a number of mandamus petitions on convenience, transfer for convenience, which we're still seeing as well. So a lot of defendants that are unhappy, I would say, particularly again with the Texas courts and decisions on transfer there, we're continuing to see a number of them try to use the Federal Circuit and the mandamus route as a way to potentially overturn those decisions. After TC Heartland, I would say we saw a lot of traction. Obviously things were new. What it means to have a practice, or what it means to have your principal place of business or a place of business for the defendant in that jurisdiction was still up in the air. So there was some Federal Circuit intervention very early on to kind of define the scope of that and provide us some further clarification and guidance before district courts were taking kind of different approaches to that. What I'm seeing now is probably more of a cooling off, though. It seems particularly in the last, I would say, 6 months or so, the Federal Circuit is issuing shorter mandamus decisions where they're basically reminding all of us in the patent legal community just how extraordinary a relief it is that you're asking for. And so we're seeing, much more short decisions that basically say that the petitioner has not met the very high standard for requesting the relief, and that there was not a clear abuse of discretion in what the district courts have done. So while I do think that it's certainly a tool that defendants are continuing, to pull out of their toolbox to use during the litigation, I think that we're seeing that there's less traction with it at the Federal Circuit. Probably in large part just a weariness to the number of petitions that they're seeing.
Great, thanks, Megan. Any other questions at this time? Please feel free to ask. I know we're coming up right on about, 1:30 Eastern time, 10:30 Pacific time as well. If you do have any questions after the presentation, please feel free to contact us. Our email addresses, you should be able to see them on the screen now.